changes in the H-1B lottery selection coming next year by Trump 2.0, by this administration, and it may turn this H-1B visa program upside down, and we're going to spend 10 minutes talking about it. I'm Sam Shihab with the law firm of Shihab, Burke, and with me,
Brian Burke from Shihab Burke here in Dublin, Ohio on this Wednesday at 6 p.m.
Weighted selection process.
Yeah.
That's the new term of art, WSP, weighted selection process.
Love a good acronym.
Yes, yeah. Weighted selection process, meaning that we are going to select H-1B applicants next year based on how they're being paid, but we are going to have a system of selection.
Well, I'm going to put an asterisk on that because I'm going to hit for the crowd what we know for sure. Last week, USCIS notified the Office of Management and Budget of a new proposed rule coming involving a weighted selection process for the H-1B visa.
You're getting ahead of yourself.
Am I?
Yes.
I thought you were.
No, because I'm just explaining it because we're going to explain the regulatory process.
Yeah. Okay.
Where we are now,
yeah,
and what we think it's going to go, and then talk about pros and cons in less than 10 minutes.
So you're talking about where we think it's going to go right now.
In less than 7 minutes.
All right.
So now, let's jump in and talk about where we are now.
Yeah.
That's what you want to talk about first. And then let's talk about the regulatory process. What's the process?
Yeah. So, like I said, the USCIS put out this notice, right? That's only the first step in a regulatory process. What they've said is that they announced to the world that we're going to be making rules to create a weighted selection process for the H-1B visa.
Now, comment on that. They're doing it the correct way. They are not skipping the process. They're going about it in a very legal way in changing the law. And that's the first step.
Yeah.
And that's where we're at now.
Yeah.
Now, what's the process that we are expecting? Okay, what's that regulatory process that we're expecting?
Notice of proposed rulemaking, a proposed rule. They are going to sooner or later, and you know, for them it's hopeful. We've seen them put out notifications like this and never actually see the rule, right? But they said,
what's the process?
It's putting out a rule, putting out a proposed rule, saying we're putting out this new rule. We want you to comment on it such that we can take feedback on it before we implement it.
So there's a government publication called the Federal Register.
Sure.
Okay, that government publication is almost the newspaper of the government. It's called the Federal Register. They publish ideas, what they want to do, and they are going to publish that. Now, they've given us notice that they intend to do that. The next step for them is to publish the rule in that Federal Register. This is the official government publication.
Sure.
Now, that gives notice to the world about what they intend to change.
Get ready for a new rule on this subject. Yeah.
Then they're going to open up for comments. So there's a period of 30 to 60 days for comments. So anybody can give a comment.
Here's the rule. Tell us what you think about it. And literally online, they have a form where you can say, you know, I'm an immigration attorney and I think this is a good idea. Or I'm a member of the public. I think I'm anybody really. But people usually give them context about, you know, saying I'm an attorney, I'm an IT worker, that sort of thing. You know?
After 60 days, they close the notice period.
Yep.
And then they take all these notices and they review them and analyze them, and then they publish a potential adjustment to their rule, and they try to address all these comments in the final register.
Yeah.
And then they publish the final law.
Yep.
And then they implement the law.
Yeah.
Now, it's a long process. Now, many many regulations went through this entire process, and it never was implemented.
Yeah, you never get a final rule. I can think of a couple of things for the prior administration where we just never got that final rule.
Yeah. And many get published, they get implemented for a year or two, and then they get canceled.
Yeah.
They cancel them, they say this is ridiculous, and they publish something else in the Federal Register canceling it.
Yeah. Now, if it seems crazy that Sam and Brian are doing a YouTube presentation about just the notification that a weighted selection process is coming, it's not, because we have a pretty good idea of what this process might look like, because the prior Trump administration published a rule on this subject. And we think it's pretty reasonable to believe that the rule that we get on this time around is going to look a lot like the last rule that we got.
More than likely.
Yeah.
So what we think the weighted selection process will be is that they're going to select all highest level 4 H-1B cap applicants, higher, level 4 engineer, level 4 teacher, level 4 IT professional.
Yeah.
They put all of these in the lottery, and they are going to select from them first. If there's any numbers left, they're gonna go down to potentially level 3, 2, and 1.
Yeah, I'll read the direct quote here. USCIS will rank and select the petitions received on the basis of the highest OES wage level, 1, 2, 3, 4, that the proffered wage equals or exceeds for the relevant blah, 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 beginning with OES wage level 4 and proceeding in descending order with OES wage levels 3, 2, and 1. Basically, favor level 4, going down to level 1.
Okay, so what we know, why this is important is because what we know is 90% of H-1B cap cases are level 1 and 2 today.
Yeah.
What's going to happen is that 90% of H-1B cap cases, if this is implemented, is going to be level 4 and level 3, or even level 4 only.
Well,
we don't know.
Why? Because people will know the system's changed, right? And it seems likely that, well, I want to unpack what you said. Do you mean that the cases that people will file for, would they be more likely to put somebody in a level 4 wage? Or is it just that you're saying that obviously more level 4s are going to be selected because they're going to be favored?
Well, the latter is the 100%.
Well, sure.
Obvious.
That's
now,
yeah.
The intent behind people, I'm not in people's heart and mind what they're going to do, but I can tell you that if you are a level 4 engineer and I'm a level 3 engineer, you're going to be selected, I'm not going to be selected, and therefore what is now 90% level 1 and 2 is going to be 90% level 3 and 4. That's all I'm saying.
Yeah, yeah.
I don't know what people will do. Are they going to pay people more, or are they going to do? We don't know.
Yeah,
we'll find out.
But you and I were talking about upsides and downsides for this, and Sam, I have an upside. Let's maybe talk about intent first before I get to the upsides and downs. We're going to start talking here. The sort of rhetoric we've heard from people talking about H-1B visas before, they believe that essentially people are getting replaced by low-paid foreign workers is a narrative that is out there, and essentially if you are only bringing people in the top half of the occupation, level 4, you've solved that problem, have you? It's an argument to make, right?
Yeah, of course. Sure. I mean, if you're not bringing anybody on level 1, 2, there's no complaint about underpaying.
Yeah. Yeah.
There was a release today of what Amazon is paying for their engineers. I don't know if you saw that. It was released. They're paying them somewhere between $100,000 to $250,000, the IT professionals on H-1B right now.
I've done some EB-1A cases for folks at Amazon, and they can go higher, a lot higher than that.
And we've done also entry level.
Yeah.
We've done, it doesn't have to be Amazon. A lot of them 150, 160.
This is very true, yeah.
Yeah. All right. So we don't like this rule. I don't like this rule. I try to like it. I try to push myself to be neutral, and I've been pushed to decide that I don't like it for a lot of reasons. So we tried to extract why we like it, and we couldn't come out with anything, did we?
I have one sort of potential way it might benefit some people out there. So bottom line, H-1B visas mostly go to people in IT and engineering occupations, right? And I guess maybe if there are less people in those occupations at level 3 or 4 wages, basically the H-1B visas might be spread across more occupations at some point, I guess. If people think that basically all the H-1Bs go to low-paid wages in those occupations, presumably there must be other occupations seeking H-1Bs that might be higher, and you might see a more breadth of occupations getting H-1B visas is a thought, maybe.
Well, that's an excellent try, but I have a problem with.
I don't love it. It didn't come out very well.
No. It's an excellent try, but I think H-1B selections are by gravity, by demand, by market driven, and that's what you want it. You want it driven by the market. Where's the biggest demand that we need here in the U.S.?
Level 1 and 2.
You know what I mean? Well, it's not level 1, 2. It's IT, engineering, STEM, not teachers. You know what I mean?
Sure. We have plenty of.
So we have. Well, it's just by demand, but maybe trying to spread it around a little bit might be a better way for the country. I don't know. Maybe you're right about that.
Yeah.
But which I will check that on the positive. I think.
Yeah, I convince you a little bit.
Yeah, absolutely. Now, we have a long list of why we don't like it.
Yeah.
And we're obviously going to run through them very quickly, and I have a feeling we're going to talk about this a lot more in the future. But what's the first thing you don't like about it? In 6 or 7 words. So we're going.
It seems non-compliant with the law.
Yeah. So the H-1B is a special occupation for people with an entry-level bachelor's degree or higher.
Coming to work in a specialty occupation, which is minimally requires a bachelor's degree, yeah.
Now they're basically shutting down the bottom half.
Yeah. And so I was sort of speculating that there might be certain occupations where basically, you might not be able to ever get an H-1B visa. Not necessarily due to the wage level you're at, but basically there are certain occupations where they just don't really get to level 4 that much,
Yeah.
You might end up finding yourself outside of that occupation. There might be certain occupations that might have trouble getting a visa.
How about it favors large corporations over startup companies? Startup companies give you sometimes low salary, but they give you a piece of the pie.
Yeah,
if we
non-monetary benefits that don't translate into a single government form where you put a salary in, right?
Future equity interest, family vacation, something that does not translate to dollars.
My note says discourages non-monetary benefits.
Non-profit, it hurts non-profits.
Yeah.
Companies,
yeah.
Huge.
Yeah.
I mean, non-profits do great things in this country. It's huge. The other one is the idea that I want to bring more chiefs. It's not really conducive of addressing where the shortage is in many occupations, like nurses, for example. Specialized nurses are H-1B nurses, but I would love to have advanced specialized nurses. But what about the bottom half of the specialized nurses, level 1 and level 2?
You need people to do level 2 and 1 work. You don't need more people to manage them.
A director of nurse, fine. A supervisor of nurse, fine. But what about the nurse, who is level 1, who's doing the work, who's giving the shot, who's coming in, checking the charts, and
and that's something the Department of Labor Policy says is basically in any occupation, most people are like, there's lots of level 1s at your level, but most people, average worker in that occupation is going to be around level 2. And that's what if you had a graph showing where they are, it's level 1, level 1, 2. There's just that's it.
If this pushes companies to pay 3 and 4 for everybody, what does that do to the economy across the board when wages now are inflated in many wages where it is competitive? That can hurt companies to be able to sustain themselves. Don't you think? Even among American workers, because if you're paying foreign workers $120,000 out of college to get them an H-1B,
they're worth it then. The marketplace will make the decision for you. If you made a bad decision to hire a foreign worker for a high inflated amount, and your business goes under because of it, well.
But that could be a problem across the board.
Yeah, I mean, in theory, people think that certain people think that H-1B visas lower wages, and basically, if everybody's getting paid higher, if foreign workers are getting paid a higher amount, that should bring up the wages of U.S. workers as well.
Is it possibly going to negatively impact foreign students to come to the U.S.?
I think that's one that really sort of concerns a lot, because it is a very common trajectory, even though you're not allowed to intend it at the time, is you come to the United States on an F-1 visa, and then you get a little employment afterwards, your OPT, your STEM OPT, if you're in a STEM occupation, and then you change to an employment visa. And essentially, if you're at a entry level, you're gonna, that smart talent we bring to the United States to educate in our U.S. schools will have no real potential path, because they're at level 1 and level 2, and everybody at level 3 and 4 is getting the jobs.
Bringing supervisors and directors does not resolve the critical need for teachers, does not resolve critical needs for a lot of positions.
It's a very broad, common narrative in immigration. It's that basically the population we have right now cannot sustain itself. We don't have the people we need to do X and Y and Z, and any sort of developed economy resolves that issue through immigration, and this proposal kind of undermines that premise.
National need does not relate to level of the wage. Level wage 1, level wage 2 could have a national desperate need in certain positions. So as well 3 and 4, but clearly one is cut off, the other one is not.
Yeah. So anything else you think is worth bringing up on the subject of?
No, I think we've talked enough about it.
I think I'm going to close this why I think it's interesting. This is the first sort of thing that's a very clear brand of this administration's changes to the H-1B visa program, and it'll be interesting to see if they go back and try to bring back any of the other changes they were trying to implement the last time around.
To me, this is a change for the sake of change, not for the sake of logic or what's good for the country or what's good for the program, in my opinion, Brian.
One thing we were talking about is, essentially they're rewriting the rule, they're rewriting the law without changing the law. They're just writing a rule. And the thing that I'm going to say again and again is, if you guys want to change how H-1B visas work, change the law. If you don't like the H-1B visa program, if you have control of the presidency and two houses of Congress, you can nix it right out of the law and replace it with whatever you want, a new program that is something different. You know?
All right, so we move on to take questions, guys. So go ahead and drop your questions, anything you need. We got 15, 20 minutes. We want to answer as many questions as you can bring in. We also have this website, immigrationquestions.us, that you can drop questions during the week. And if we don't bring it here, we will reply to you directly. Either way, you will get an answer from immigrationquestions.us. That's our website. To just encourage you to drop questions during the week if you don't have time to attend, and we will do our best to reply to you or bring it here for an answer as well. Be that as it may, we have a good question here by Empire, Brian. So this is, I believe, deals with the notice to appear, I think.
Yes.
Question that the government is saying that the 60-day grace period is discretionary, and therefore they can issue a notice to appear. As you look for that, I'll answer that one.
Yeah.
I have a problem with that. Let me tell you why I have a problem with it. I think there, and I don't have the language in front of me, but I do think that the 60-day has a discretionary clause in it.
That's my vague recollection, yeah.
But however, a discretion, so you guys understand, a discretion by the government doesn't mean that I'm going to give it to this guy and not give it to that guy. That's not the discretion law understands. Discretion the law understands is that you can come out with a policy across the board and say, we're not doing grace period across the board. Or you can come out with a policy that says, we're doing only 30-day grace period, you know. So you can come out with policies to manage discretion. So discretion doesn't mean freedom to discriminate or a choice to implement sometime and not implement other times. That's not discretion in the law. What's in the law, discretion, is that you have to have a clear policy. So I think they lose on that one. Brian, do you have one for us here?
Yeah.
From immigrationquestions.us?
It looks like it's from Din on immigrationquestions.us, our fun little website.
And for you guys out there, drop your questions. We'll take them as they come.
I do apologize, I have to abridge it a little bit, but here's the question from Ben. Is there any benefit to apply for EB-1A through my employer with them being the petitioner versus using an independent attorney like yourself and self-petitioning? So I want to rearrange this question asker's head a little bit and let them know that your EB-1A is a self-petition application. I mean, you're going to be the person who's signing off on behalf of that. It's always going to be an application by you. However, it is having the support of your employer in this application and thereby having involvement has value. If you are doing something in your occupation, in your field of endeavor for your EB-1A that is very intrinsically tied to your work with your employer, that evidence from that application might be useful. And having the support of your employer in your application, having them involved, means you might be able to get more of that evidence. That's one reason why it might be good to have your employer involved. But, you know, I do love doing an EB-1A application for somebody who we don't represent their employer, because it's no holds bars. As long as my client's complying with the terms of, say, their employment agreement, I can do whatever I want to get that case approved. I'm going to be, you know, chewing on the drywall, bouncing off the walls, making all the best arguments I can, and that's, you know, I'm not held back by that employment relationship.
So I think the question here, no, you're right on the money. The question here is that about the attorney selection rather than the employer involvement.
Yes, to be clear, the rest of the question is, I won't name the firm, but it basically says, my employer's in the process for petitioning my EB-1A, but I haven't been very happy with the lawyer from their law firm they assigned.
Right. So it's really a choice of lawyer rather than an attorney now, and therefore I think the answer to the question is you need to forget about this attorney is related to my employer. You need to find the attorney you're most comfortable to work with and you trust. Now, there are advantages, disadvantages, obviously, between having an attorney that's tied to your employer who has a dual responsibility to, you know, fiduciary duty to you and to your employer, whereas an outside counsel who has a duty to you only. But really the competence of the lawyer, it really what it comes down to. You need to hire the most competent lawyer for you, regardless of whether that lawyer is your company's lawyer or not your company's lawyer. And that's the advice I would give.
Yeah, I mean, but I would say if you're stuck with who you're stuck with, if you feel you can't get out, bottom line is you can be a good advocate for yourself. If you put in the work, you can make your case better by basically filling in the gaps where you don't think your attorney's cutting the mustard. It's not the ideal scenario. I don't like it, but if you feel trapped.
He has one petition, Brian.
Yeah.
He has one petition and one shot at this. He needs to get the lawyer he's comfortable with and should not file a case with a lawyer he's not comfortable with.
How do you feel about this? So you have the attorney who's going to be filing the case for you. Can you hire your own private attorney to basically sort of be, your secret attorney on the side to help to essentially write the case for that attorney to produce some real quality work that the other attorney is not capable of producing? Just sort of spitballing here. Like your own personal consultant on the case.
I wouldn't take it. I wouldn't take it as an attorney because there's a complete disrespect to the other attorney.
Yeah.
And I wouldn't accept it if I'm the attorney that somebody hired an outside counsel. That means he doesn't trust me. The basic foundation of an attorney-client relationship is trust, Brian.
Yeah.
And if there's no trust, there's no attorney-client relationship that is healthy and positive. Yeah. And therefore, the breakdown of the relationship means that this person needs to move on to a different law.
I asked that question of you because I've been asked that question before myself, and my answer is, well, it sounds kind of fun, but I'm not a ghost writer. I can't really represent you if I can't control the case.
It doesn't work. Life is too short. It doesn't. It's ultimately what's in the best interest of the client, and this dual relationship is not in the best interest of the client. It's not the best interest of his case. It doesn't work well. Yeah. All right. Do we have any?
Oh yeah, we have one more, at least one more from here from immigrationquestions.us, okay. And let me see if I can get it in here. Here we are. Go ahead,
my spouse and I are outside the U.S. and there's an RFE on my I-45 application to submit our medical records. Will there be any problem submitting it from outside the United States, or should we come back to the United States to file the medical report? If there is, and I don't think there is, a medical doctor who is certified by USCIS overseas where you reside, there's no problem. But I don't think there is.
Yeah, I'm just curious here. USCIS civil surgeon. I don't think they have civil. They have. For those who aren't aware, USCIS calls these approved doctors. They call them "quote unquote" civil surgeons. And I'm just gonna, just type in London, UK, a big city overseas, and it's not going to find anything. They ask you to search by zip code. It's just giving me things located here in Columbus, Ohio. Yeah, that's going to be the problem. I agree.
So yeah, you need to come back to the United States. Now, I wouldn't ask for an extension on RFE, too risky.
No.
I would get back and get that done here in the U.S. You need to call right now. You need to set an appointment so when you fly in, you have the appointment so you're not surprised that you cannot get in and meet the timeline on the RFE. All right.
Okay.
All right, let's go into the next one, Brian.
A nice broad question from Gangadhara Simha. Any prediction for 2015 June EB2 in the next 5 years?
If I have a prediction in the next 5 years, I'll be a billionaire.
I don't know I'm not sure how you're going to monetize that, Sam, for the record.
But that's a darn good insight. We don't have that prediction. Let's be honest about that. We don't know. Yeah. We have, holy cow, 5 years. You're talking about President Trump changing the law and Congress and the economy going up and down.
I will give some perspective on this. I don't have a prediction either, but I'm going to give everybody a reminder. EB2, India did get to January 1st, 2015, right? It's been there. Meaning, and everybody knows somebody who has like a 2014 priority date who got a green card, and congratulations, buddy, but you also want to wring their neck because you're waiting. You have an older priority date. You've been waiting. The positive thing I can say is that the massive availability of visas in the past that sort of thinned out the metaphorical herd with 2013, 2014 priority dates means
Give me a prediction, Brian.
Means there's. Hey, let's be happy. Here's what I'm going to say. It's not a prediction. It's going to be. Let's be happy that they had massive visa availability in the past, because it means you're going to get there faster than you might have otherwise.
You're the ultimate optimist.
I am the ultimate optimist. It's all I have.
Let's take the next one.
Yeah.
Wahuri, who's asking for his friend,
Yes.
well, we'll accept that. You can ask for a friend. It's okay. We're not going to tell anybody that it's your friend. We'll accept that. Pending adjustment of status and just got called for an asylum interview. Should he withdraw his asylum case or show up on the interview and deal with the asylum case? Okay. You are. I'm going to give you the legal answer. I'm going to give you the practical answer. And then I'll listen to your input. You should pursue each and every available legal avenue you have 100%. Your friend has an asylum case, and there's an interview, and you have a pending adjustment. Both are legitimate cases. Pursue it. Now, the practical side. There is a very negative energy right now around asylum cases. And not your friend for sure, most likely, I hope, but many asylum cases are just full of incorrect information or made up stuff. If there is made up stuff in your friend's asylum application, withdraw. Get out of it. Because that's fraud and that's a problem. And I'm not saying he has done that, but there's so much of that, unfortunately, and that's a big frustration by the government. And that's my answer.
I agree with everything you said. The thing you say about pursuing every lawful path to immigration until you have one in your hands is something I say practically verbatim. People probably want I picked up from you. But that question cannot be answered without a major kind of intense analysis, because when I hear somebody has pending asylum, I'm wondering, have they been maintaining their non-immigrant status in the United States? Because essentially, for any employment-based immigration, actually, I'd be questioning whether or not. Okay, so for employment-based immigration, there's a requirement that you be in lawful status to apply for adjustment of status, right? And I would be interested in thinking about what does the withdrawal of that asylum impact. What status were you in when you applied for your employment-based adjustment of status? Does getting rid of that asylum case potentially impact their ability to prove the I-485, essentially? Because approving a I-485 for somebody with a pending asylum, and if that's all they have that's keeping them lawful when they file the I-485, it's not a given that they can approve that adjustment of status. That's something we've researched, pretty intensely around here before.
Yep. Next one, Brian. Empire. What is the probability that the courts will stop this new H-1B proposal? I do have the probability. You know what's the probability? I'll give it to you. 50-50. You know what that means? That means I don't know. We don't know what the rule is. We don't know what's going to come out. We don't know whether it's sound. And we don't know how left-leaning or right-leaning the judge is. So the answer is 50-50.
Well,
I like my answer.
I want to elaborate a little bit more. Sam, okay, let's give odds. Odds that somebody's going to sue on this issue.
95%.
Yeah. Now,
100%.
100%. Yeah, I'm there with you. Now, odds that somebody gets some sort of injunction preventing this thing from being implemented, and that's the interesting thing. This has gone down a lot since the Supreme Court case on birthright citizenship, where they said nationwide injunctions preventing the executive branch from doing things like this are a lot harder to get now. And that's sort of the really interesting ripple about the world we're living in right now versus, say, 4 years ago.
Yeah. We hit 6:30. Thank you guys for listening to us. Come back Wednesday. Well, today's Wednesday.
Monday.
Come back Monday at 6 o'clock Eastern Time, and we'll do it again. Drop your question at immigrationquestions.us. You can get your answer back either here or there. You can drop them here and come in and drop them also here in live, and that will double your chances of getting your questions answered. Guys, have a